Retaining the law firm. Okay, this is a really important, critical step in what it is you're going to do next. We've already gone through you're maybe being investigated, where one is then ultimately charged and arrested, and what happens during that process. And now we dealt with detention hearings and what can happen during a detention hearing, what used to be referred to as a bail hearing. You don't have bail anymore in New Jersey, a detention hearing. Okay, so all that has calmed down, and you're doing the two most important golden rules that we've talked about. One, remain silent. Again, I emphasize, whether you're guilty, not guilty, innocent, not innocent, doesn't make a difference. Remain silent. You have a right to remain silent under the Fifth Amendment of the United States Constitution, and corollary rights in the state government, and you should exercise it. And then the second golden rule, hire the best lawyer you can afford. All right, you found that law firm, you found that lawyer, you're ready to rock and roll. Be aware. The ethics rules require, and for good reason, that there is a written retainer agreement that is prepared by the attorney and given to you. And until both parties, the attorney and you, sign that retainer agreement, you should not proceed with representation or be represented by the attorney. The retainer agreement is like a contract. It is going to set out for you various things. I'm going to explain what some of those things are in the retainer agreement so that you, and you should be fully familiar with the scope of representation, and that the fee that's agreed to, what it covers, and as importantly, what it doesn't cover. Now, a retainer agreement is basically going to start out with, and by the way, let me just say, sometimes there's just forms that people have, and they're very pro forma, we call them. Ours are very, very in-depth. They spell out very specifically what the scope of the representation is. What you can expect to see on that is, of course, the name, your name, the name of the law firm or attorney that you're going to hire, and generally a caption of what the matter is, State versus Jones, State versus Smith, whatever it may be, and a description of the charges, aggravated sexual assault in such and such a place, murder in such and such a place, whatever, and a complaint number possibly if the lawyer has it. And then it's going to explain that there's going to be a fee and what that fee is, and what that fee includes. The representation should be, in my humble estimation, especially for a criminal defense attorney, explaining to you everything from the moment that the representation begins all the way up to and through a trial, should a trial be necessary. Now, most cases don't resolve by way of trial, but the retainer agreement should be there and should be spelling out what your financial obligations would be under those circumstances. What you want to avoid, and unfortunately I see still going on out there today, is where you have no idea, you have no retainer agreement, and the lawyer is saying to you, I need another $2,500. I need another $5,000. Oh, to file the motion, I need that. That is unacceptable. It's not only unethical, it's unacceptable. So as a consumer, you need to be smart. You need to say, wait a second, I need something in writing as to all the costs that are associated with the representation up to and through trial. Now, most retainer agreements in a criminal context are not going to cover certain things. For example, if you need investigative services, if you need expert witnesses, if a matter has to be appealed either during the case or after the case to the appellate courts. Typically speaking, most retainer agreements are going to say that the fee that you're providing to the attorney is not going to cover those things. That would be a separate agreement that you would have to enter into. In a criminal case, typically what is covered by the retainer agreement is everything from the beginning of representation, the filing of motions, the reviewing of discovery, the assessment of the case, client counsel, plea bargaining with the government with respect to seeing whether or not there's a way you can resolve the case without the need for a trial, motions that are legal arguments that would need to be filed. For example, a suppression motion or a Miranda hearing, if there's going to be an assertion that the government did something that was in violation of your constitutional rights. All of those things would be included in a typical criminal retainer agreement, as well as, if it needs to, if there can't be a resolution, an actual trial before a jury. Now, there can be certain things in an agreement where it's broken up to that additional money would be required when you hit different stages. I have heard and I've seen plea agreements that will be in the beginning stages. This is the retainer. If you're indicted, there'll be an additional sum of money that's owed. If the case has to go to trial, there'd be still yet an additional amount of money that would be owed as well. That is a form of a retainer agreement you can have. And typically that's entered into because the client may want it broken up and not have to pay a lump sum in the beginning of a case. And then there are some retainer agreements that require a lump sum in the beginning of the case. And there are retainer agreements that have a lump sum, and then there's hourly rates that are charged against. So there's various different formulas that lawyers use in order to come to a reasonable fee in a case. But the important thing is to make sure that whatever that agreement is, that it's written down so that you are not surprised down the road. You shouldn't be. Unfortunately, it does occur. And this way you have the comfort of knowing that this is what my financial obligations are going to be. Listen, financing a case is probably the most critical thing next to remaining silent, hiring the best lawyer you can afford, is being able to afford that lawyer. So it is critical whether or not you have the funds, or you can get the funds somewhere, that you do have the money to be able to pay the attorney, and a good attorney, because this is an investment in your life and it's very, very critical. So it's important both for the law firm and the client to have an understanding and a meeting of the minds as to exactly the fees that are owed and what is covered in those fees. If you have a situation, in my opinion, respectfully, in which a law firm is telling you either they're not going to send you a retainer agreement or they don't talk about a retainer agreement, to me, that's a red flag and should cause you some serious, significant pausing. In fact, in my mind, if I were giving you advice, I'd tell you not to hire a firm that is not talking to you about the retainer agreement. It is very important that a credible lawyer and a credible law firm set client expectations from the beginning in a realistic way, not a sales way, in a way that does justice to the client so that the client understands what their obligations are, the law firm so that the law firm understands what its obligations are, and therefore hopefully never have to talk about what the retainer agreement covers or doesn't cover, because that was done all the way in the beginning of the case. Very, very important aspect that I don't think I've ever seen a video out there on for sure, but maybe if there is, certainly something that you should make sure that you take into consideration. What does the retainer agreement say? And if you have any questions about it, because it's a very heady language in it, ask your lawyer. At least a good, competent law firm and attorneys want to make sure you understand everything in the beginning, because you don't want a dissatisfied client. I hope this video was helpful. Please look at the rest of our other videos that we have. We try to do practical things that we deal with every day in our career. Our team of former prosecutors, with our core values of courage, compassion, and commitment at the Bianchi Law Group, are here to serve you. And we hope that even if you don't retain the firm, wherever you can reach out to us, that these videos will be helpful to you, your family, or friends, should you find yourselves in an unfortunate situation that you're either being investigated or charged with. Thanks for watching.